Professor Orrego will make the first question to start the dialogue, and then everybody can send me the questions they have. They can write it in English or in Spanish, and I will try to summarize them and select some of them for Professor Finnis to answer. Thank you so much, Professor Finnis, for being here. We're very honored to have you here, and you can go ahead and start.
Thank you very much, Javier. I've been asked to talk to you about the philosophy of law and fundamental rights in the Constitution. And I've been teaching the philosophy of law, or jurisprudence as we call it in Oxford and Notre Dame. And to some extent also teaching constitutional law. And I've been expounding mostly the constitutions of states like the United Kingdom and the Commonwealth of Australia that do not have a set of fundamental rights inscribed in a document called a constitution. But it's unclear to me what I should say to you at this introductory stage. I'm keen to listen to your questions and respond to them. I of course think that the philosophy of law today is basically the philosophy of law that was taken to be the best philosophy of law in the 13th century by Thomas Aquinas, and in the 15th century by followers of Thomas Aquinas, great judges in England, who were instrumental in expounding the Constitution with a small c, no document there, but the fundamental rules of the common law as they regarded government and citizenship and rights in England, as they developed, especially in what we could call the sort of formative period of the English Constitution in the early 17th century, when the great judges who laid down a kind of separation of powers appealed directly to Thomas Aquinas for their understanding of the fundamentals of good government. So my philosophy of law is essentially a philosophy of law that has been underpinning the thought of English, or you might say common lawyers, for many centuries. And it conceives of fundamentally two kinds of law, and then of a set of interconnections between them. So there's natural law and there's positive law. And natural law is another name for moral law, or moral precepts, moral principles. And moral itself is another name for reasonable precepts and principles, which articulate what is required, what's needed to respect and promote the common good. That's to say, most fundamentally, the humanity, to respect and promote the humanity and personhood of each human being. So the natural law consists of a set of negative and positive precepts, or affirmative precepts. The negative precepts exclude from one's conscientious deliberations all intending of harm to other people or to basic human goods. The affirmative, or in that sense, positive precepts delineate responsibilities to promote and advance the well-being of persons, especially those persons with whom one has relationships of dependence or interdependence, like parents' responsibility for children, and of neighbors for neighbors, fellow citizens of fellow citizens for fellow citizens, affirmative responsibilities to aid, assist, protect, etc., contribute to the well-being by the contribution of work or of funds, and of course always of care and precaution and so forth. And in general, one can say when one of these precepts or principles identifies something as that could be called my duty, a responsibility precise enough to be called a duty, then we can talk automatically, in effect, of a correlated right. The right that corresponds to is correlative to that duty. So if I have a duty to someone or in respect of a set of other people, then those people or that someone has or have a correlative right that I should do my duty, that I should carry out my responsibilities, affirmative or negative responsibilities. So their rights can be, again, parceled up into those that correspond to negative and those that correspond to affirmative duties. And so we have the logically necessary conception of natural rights, something that's, even if it's not, even if it wasn't a feature of the lawyerly or citizenly idiom of the 13th century or of the 3rd century, in Latin especially, it was implicit in Latin as it has become implicit in the modern European languages, more or less derivative from Latin, including English, which is full of Latin, like the word right and the word responsibility, and indeed the word law. So there are natural rights. We can call them human rights if we like. They are also describable as simply moral rights. And then the positive law, it consists of a set of concretizations or determinations or specifications, making more specific these moral precepts, these natural precepts or natural rights. And the whole of English law, or the common law, and thus American law, as it developed before American independence and immediately after American independence, was stated classically by the great Oxford professor and then judge William Blackstone, Sir William Blackstone, in his lectures of 1765, which became the great 4-volume Commentaries on the Law of England, which is foundational for American law. The whole of the law was expounded by Blackstone in terms of rights. Some of them what he called absolute rights, by which he meant natural rights, and some of them what he called established rights, which I've been calling positive rights. So by absolute, he didn't mean exceptionalist, although some of the absolute rights, such as the right to life, are exceptionalist. The duty is never to, without exception, never to intentionally kill, and so forth. So the common law can be expounded in terms of rights, although the judges on the whole tended not to speak so much of rights as of rules and their implications. When Blackstone expounded the law of England in 4 volumes in terms of rights, he was articulating both the common law established by judicial decisions of the courts over the centuries, and the statute law, the law laid down by Parliament, by an elected or partly elected legislature over the centuries, or last week, statute law changing frequently, common law changing only gradually, and all of it a set of positive law rules, some of which are also directly, straightforwardly natural law precepts. So the natural law precept against killing or killing the innocent, those who are not threatening your own life, are also the rules identifying what counts as murder or a homicide of the worst degree. And indeed in England and in Australia, where I learned my law, the definition of murder was established only in the common law. It was not laid down in a statute or a code. A constitution then is, I think, a kind of agreement at a particular moment in the continuous life, the ongoing life of a set of persons willing to treat each other as a community, as a set of independent people, as a kind of agreement at a specific moment of time about how to govern ourselves, how they should govern themselves indefinitely into the future, governing themselves according to the law established in the Constitution, a kind of special positive law, by establishing a system of offices and responsibilities, some of the offices being legislative, some of them being executive, some of them being judicial. I did my doctoral thesis on that distinction of powers that I just made use of. You can see it already in Aristotle, and I traced the history of that sort of distinction of powers through Aristotle and the Middle Ages, and Jeremy Bentham's attack on it and Hans Kelsen's attack on it, and then I traced its fate in the Constitution of the Federal, the Commonwealth, the Federal Commonwealth of Australia, established in 1900 with a sophisticated constitution with its 3 chapters of executive, legislative, and judicial power, no Bill of Rights, a powerful High Court, Supreme Court, with administering the Constitution and administering as final appellate court the common law and statute law of each of the states on appeal from the state's own, a state's own Supreme Court. And I spent some of my time in Oxford as a consultant in constitutional matters for Australian state government, and spent a lot of that time resisting moves which looked like succeeding in the 1970s to adopt a Bill of Rights, a Charter of Fundamental Rights, into the Constitution of the Commonwealth of Australia. And at the same time, in the early 1980s, I had the privilege of working for a committee of the House of Commons of the United Kingdom, which was grappling with the problems involved in the final independence of Canada, a great former dominion of the British Crown, comparable to the Commonwealth of Australia. And in the course of that final separation of these 2 already independent states, Canada chose to adopt a Charter of Rights into its constitution for the first time. So from 1867 to 1981, Canada had no fundamental rights in the constitution. And in 1981-82, they adopted a charter. And the committee of the House of Commons advising the Parliament in the United Kingdom regarded itself as not entitled to consider at all the wisdom or any other aspect of the Canadian Charter, but only certain intra-federal problems about the relationship between the provinces of Canada and the central Parliament and government of Canada. It was the Parliament of Canada that was applying to the Parliament of the United Kingdom to sever their final link by a British statute. And we in Britain took the view we had a responsibility to the federal people of Canada not to simply accept the invitation of the central government and Parliament, but to consider whether it had sufficient assent from the provinces. But we could not consider the question of the Charter of Rights, which was part of the federal government's proposal. So that proposal eventually gained sufficient assent from the provinces under the spur of prodding from the British. And with it came a Charter of Rights, which had the effect, as I foresaw, of very substantially changing the Constitution of Canada and the politics of Canada. And it was a great transfer of authority to the judges, and thus to the central executive, which appoints the judges. And questions formerly debated and decided in the Parliament of Canada and the legislatures of the provinces are now decided by a federal judiciary. I think the politicians of Canada did not fully appreciate what they were proposing and accepting in that adoption of a charter. Some of them certainly did and looked forward to the change. Many didn't fully grasp the significance of the change. So that's one of the questions that a people has to decide for itself in adopting a constitution, whether to confer on a judiciary and those who appoint the judiciary this power that goes with the articulation in the Constitution of a set of fundamental rights and the decision of what the implications of these rights are, on the assumption that the rights are, so to speak, superior to the legislature's own decisions. And I think it's the last thing I want to say is, before tackling your questions, is that it's easy for lawyers, especially those brought up in a system with a system of fundamental rights administered by a supreme judiciary. It's easy to assume that without such a structure of judicial supervision, rights are somehow excluded from the polity or are no part of the responsibility of the legislature. But I would say that, in fact, it is always and has always been understood to be the responsibility of the legislature and each member of the legislature to respect human rights, to respect fundamental rights, to respect the historic rights of the people, as was the normal common law conception of the matter. Whether those rights have been articulated in a document like the Magna Carta of 1215 in England, or whether they had not been articulated, but were part of the set of working assumptions of the courts and of those who litigated in the courts, who might litigate in the court, or who debated in Parliament, or who carried on the government as ministers of the king or queen. Now, whether any of those remarks has intersected with any of your concerns, I know not, and I'm not concerned to find out. What I am concerned to find out is what questions you have, and then I'll do my best to answer them. So thank you very much.
Thank you, Professor Finnis. I will make use now of the professorial or old age privilege to start the conversation with my question, and then give to Javiera the opportunity to summarize some of the questions of the students. I have the following concern. There has been a lot of debate, and you tackled this issue in your Maccabean lectures many years ago, before the Human Rights Act, about how a democracy can, so to say, reach some sort of equilibrium between the power of the majority, which is expressed in Congress, and the rights of the minority or even a single person, which are traditionally defended by habeas corpus or some other sort of judicial remedy before ordinary courts or the Supreme Court or the Constitutional Tribunal, such as the one we have in Chile or the tradition in Germany and Spain. But to what extent is this dichotomy reasonable, or just some other countries, as you have told us, Australia has no charter of human rights, but they have a good record of state protection of human rights. And so it seems that there must be some sort of misunderstanding here. But what other mechanisms could one have to protect individual rights without a charter of rights? And how does this relate to democracy as a form of government? That would be my question.
Yes, I think the answer is to some extent different in each community, and what's the reasonable way forward for a community if a moment of decision comes for it, like a constitutional convention or such like. The answer to the question is, shall we adopt a powerful constitutional court, or shall we make use of the existing court, or should we confer on the court no special constitutional jurisdiction, but allow them to consider appeals as they come from common law, from statute, and some of those will involve fundamental rights and they will deal with them according to law. Or should we, for example, because there's a threat by majority to minorities, should we divide the legislature between communities, and has been attempted in various countries like Cyprus, for example, to assign seats in the legislature to specific communities, partly ethnic, partly religious, etc., and then lay down in the constitution some kind of restrictions on the kinds of law that can be made by the whole in respect of some part, etc. Now, such complicated artificial arrangements may be the only way forward. They tend to be unstable, but they might not be. It might be that was the only way. And if you had a division of communal rights on those lines in the legislature, you might also have it in the court. So the number of seats reserved in the court, whether or not the court had constitutional power. I think it's inevitable once you get a complex to be supervision of it in some respects by the courts. So although we have no constitution in the United Kingdom, in a crude summary of the position, it's undoubted that that all those statutes, all those acts of parliament that apply to the executive, to ministers, will be enforced by the courts as a matter of course. Whether or not they're called constitutional or not, and indeed none of them are called constitutional. And that's simply part of the automatic law that the court, the automatic principle, you might say, that the court administers the law, the whole of the law, and the statute law has a priority over common law and a priority over political conventions. So there we are. We have a powerful court, and that there's been no sort of specific decision about how to go forward, except that the courts decide according to law and must uphold the law. So you mentioned habeas corpus as the traditional instrument through which the English courts for centuries preserved the rule of law against powerful barons and private interests, or against ministers of the crown. And the fact that such and such was done on a royal warrant was not by itself a sufficient ground for making lawful what was otherwise unlawful.
Thank you. Thank you very much. Javiera, I leave the word for you. Thank you very much, Professor Finnis.
Okay, Professor Finnis, I'm going to make the first questions, which is by myself. The first question is a two-part question. The first one is, do you believe that after the Human Rights Act, this has affected in the judicial activism of England's higher courts? And if so, can you give us an example so we know of what kind of activism you are seeing in your country?
Well, yes, I think the advent of the Human Rights Act, which came into effect in 2000, and broadly tracks the content of the European Convention of Human Rights, has significantly affected what we call judicial activism, perfectly reasonable shorthand for a complex set of attitudes and decisions. It's a little bit difficult to identify what's a result of the adoption of the Human Rights Act and what was already part of the zeitgeist. So English administrative law, much of which of course involves the intersection between the courts and the government, with Parliament in the background. English administrative law had been, as I say, in line with the zeitgeist, developing rapidly from the early 1980s. By various technical shifts, the courts undertook greatly enhanced responsibilities of overseeing administrative, meaning often ministerial, executive central government action. And so that was fully in process when the Human Rights Act came into effect. And some of the results in terms of activism go outside the Human Rights Act. So I think the extraordinary decision of the Supreme Court of the United Kingdom to declare unlawful the prorogation of Parliament in August 2019, was it? Had nothing to do with human rights at all, but was, I think, unthinkable but for the activist mentality, outlook, assumptions of the judiciary, which had got used to administering the broad programmatic declarations of principle that you find in the Human Rights Act, and in particular in making judgments about policy and what's reasonable in a very general sense of reasonable, that are required by the concept of proportionality or any equivalent concept. So proportionality is not written into the European Convention or the Human Rights Act. What is written into the convention, the structure of the convention, the structure of the act, is a programmatic declaration of a right, say the right to private life, and then a second part of the article which states various grounds on which an authority can interfere with very inept drafting, very incompetently drafted. These are not interferences with rights, they are specifications or identifications of the limits of the rights. But whatever the technical, conceptual roughness or sophistication, doesn't matter, of this, the court is required to measure, in some senses measure, the suitability or appropriateness of such and such a measure in relation to such and such a very vaguely defined value or concept like private life. And so the courts have, the Supreme Court has got very close to introducing assisted suicide. Majority held that it was not appropriate to introduce it until the legislature had spoken or had considered the matter further, but they didn't promise not to introduce it if the legislature didn't make the right decision. Although another majority seemed to say, no, it's for the legislature anyway, and it's not appropriate for us. But a strong minority were willing right then and there to declare that there's a right to assisted suicide, which would bring with it inevitably euthanasia. So that's just one example among many, a sort of spectacular example. But and that's an example of where the court itself, to some extent, behaved responsibly and reflected on this problem of the division of responsibilities between the democratic legislature and the non-democratic judicial powers.
There's a question also from Maria de Los Angeles Mena, which is kind of related to this. She wants to know if you feel that there is a need to regulate or incorporate bioethical principles in the Constitution, since we already have a Charter of Fundamental Rights. So that way we can prohibit things like abortion or euthanasia. What do you feel? Do you feel that it's important to incorporate such principles?
Well, in the end, I think one has to face the reality that that if the majority or the working ruling part of the people, whether you call them the elite or not, are determined to introduce some what they regard as reform, some new legal institution, they are likely to be able to accomplish it through one constitutional mechanism or another. I'm not saying that it's useless to seek to make that difficult or to make it as near impossible as it can be made. I'm not saying that's useless, but I am saying I think the bottom line is that if there is, for example, a substantial majority sufficient to amend the Constitution, then that's it. If the whole of the judiciary, substantially the whole of it, are determined that such and such an interpretation of a right is or has the implication of violating, as we would say, some bioethical principle, they will carry it out. So that's not a recipe for saying yes or no to the question. I think in reflecting on this in the context of of Britain and its Human Rights Act and the debate about whether the European Convention should be replaced by a British Bill of Rights or not, whether we should revert to the pre-2000 situation where we had no Bill of Rights as such that had automatic legal or direct legal effect. I think the best one can do to hold the line at some principle that one regards as a true principle is to say, if we have a Charter of Rights, Bill of Rights, British Bill of Rights, whatever, then the court in administering it is not authorized to make a declaration or to enforce a declaration that would, so to speak, reverse a law that was in effect at the time when the Constitution came into effect. So I think that was a device tried and used with some success, I think, in a number of the constitutions that were drafted in London, but came into effect in, for example, some of the states of the West Indies, as we call them. There was written into the Charter of Rights a restrictive principle that none of these rights authorize the invalidation, I'm not quoting, the invalidation of a legislative provision in force at the time when the Charter of Rights, Bill of Rights came into effect. That very simple device would, I think, if you have a satisfactory, bioethically satisfactory law now, that would be a way of securing that it can only be changed by referendum or perhaps by some, by the legislature. You could then make it changeable only by referendum or changeable by the legislature, but not changeable by the judiciary. Is that, I'm sorry, did I make myself clear?
Yes.
Enough?
Yes, well, actually, we had that problem, and it was actually judiciary who changed our basis about right to live regarding abortion. So it's a very complex topic. Also, someone asked.
Well, let me recommend that. I don't know whether that thought is a part of your debate. If it is, well, good. If it's not, I recommend it. The thought about such a no going backwards.
Yes.
Yeah.
Okay, so John has a question also regarding abortion. He wants to know that from a natural law perspective, what are the mistakes or successes of approaching abortion as a natural right?
Sorry, what are the mistakes?
Yes, I don't, okay, I'm not sure I understand the question, but.
Well, may I intervene, please? Well, what happens,
yes.
I think that what happens is that in many places, many years ago, the right to life protected the unborn, but today, many people are proposing a right to abortion as a natural right, as a human right. Mm-hmm. The new human rights, not only related to abortion, they are related to many other issues in which, in fact, one can say they go straight against, for example, the Universal Declaration of Human Rights. Yeah. And so I suppose that the question is about the abortion considered falsely, erroneously, as a human right. How would you respond to that from a natural law perspective?
I think one just has to start with the fact that the baby just before birth is the same as the baby just after birth. And so any idea of drawing a line just at birth such that it's permissible to treat the baby just before birth or before birth as not a baby, not a human being, is unjustifiable, is irrational, is unreasonable, and is a manifestation of a will to power over the vulnerable. And just because the power is very desirable from some point of view, some individual's point of view, doesn't make it reasonable or justifiable or right. And so the question then becomes, once one acknowledges this factual truth that we've got the same human being, just one side and the other side of birth, what are the implications of that? And does that individual human being only come into being just before birth, or no, it turns out the truth applies throughout the life of that human being. Now, there is a kind of tension between the interests of that human being and some of the interests, and sometimes the obvious and true interests of his or her mother during pregnancy or after giving birth, but let's say during pregnancy. And so a reasonable law will have to make a reasonable accommodation between the vital interests of the mother and the vital interests of the child. And I think the classic law of our civilization, as it crystallized in the 19th century, for example, when these truths about the reality of the unborn were most clearly articulated by scientists and doctors and were acknowledged by the community and given effect in legislation. The set of arrangements then for defining what was lawful and unlawful in the way of termination of pregnancy was a reasonable accommodation of those vital interests, and can be defended and should be defended as a matter of reason and justice. So the fundamental mistake made by communities that have lost sight of that is to adopt a viewpoint in which simply the interests and perspective of one of the parties, the woman who has become a mother, perhaps unwillingly, she didn't intend to. I'm not thinking especially there of rape, but just she didn't mean to become pregnant. She has, so she's a mother. She doesn't want to be. And if you just look in terms of her interests, she's visible, she's powerful, she's articulate, she has articulate associates and friends. And so the relevant tension and the reality of the presence of two persons is systematically lost sight of, and indeed audaciously denied by claiming that there isn't another person, there's just a blob or something, or just by turning a blind eye and talking only about the reproductive rights of the adult person in question.
Javiera.
Thank you. I have two more questions. One is from Jesus, who says that he's doing a thesis on natural law and is currently studying public policies. So he would like some suggestions about how to...
He is studying what?
Public policies. It's a career regarding the public policies from the country.
Mm-hmm.
Okay, so he would like to know how to support the public policies on natural law.
Well, natural law, as I indicated in my early remarks, is just a sort of fancy traditional name for moral principles, and moral is itself just a traditional name for principles of reason, of what counts as a reasonable choice, when it's a choice that impacts, as all significant choices do, on the well-being of either the chooser, the choosing person, or of other persons, an other person or other persons, or both. And since what's good for me is also in principle good for you or for anyone, we have human goods that are as intelligible in the life of somebody else as they are intelligible in the life of myself, the choosing person. So any responsible policy, either private policy or public policy, is one that that passes the test of reasonableness. And some of those tests are acknowledged by everyone. So for example, the golden rule of not doing to other people what you don't want them to do to you, and doing for other people what you want them to do for you, a kind of conception of fairness, or a kind of equity between us, equitable relationship. And some are treated as esoteric and moralistic and so on, when in fact they are important truth which perhaps somewhat indirectly impact on the well-being of everyone, as is the case with the truths about sexuality and marriage. So sexuality is significant because marriage is significant, and marriage is significant because marriage involves children. And children are significant for parents because it's not just a relationship of bringing someone into being and then saying goodbye. The well-being of the child, and that means the well-being of each member of the whole community, the wide public, ultimately was shaped by their early weeks and months and years, and there's no definite cutoff point in which the parents cease to be responsible, in some sense, responsible for the well-being of their children. So children brought up by persons who were not committed to each other in conceiving the child suffer a disadvantage, an injustice that needs to be acknowledged when thinking about what's reasonable in the way of choices to engage in sexual relations that might involve children, or sexual relations that don't and couldn't involve children, but it do involve, as it were, saying to oneself or to others that sex is not just for marriage, but for something else. And that changes the meaning of the marital act, the conjugal act, for everyone. Anyone who's willing to listen to that thought and accept it has got a different conception of marriage, and therefore a different conception of justice to the child. So it's public. But the connection between injustice there and the public policy is more difficult to see, more indirect, and more controverted, therefore, and in fact now widely denied and treated as an occasion for, as we will know, hostility and serious accusations that we're in the wrong and they're in the right. Okay,
and last question. Since you already, you know that we have a Charter of Rights, and it's going to be very important in the new Constitution. The principal matter about this charter is about social rights. We have these social rights that are not just justice.
Yeah, I don't know. Justiciable. Yeah.
Justiciable, exactly.
Yeah.
So, in the point of view of moral law, since these rights are about the basis of livelihood, do you think that they should be justiciable?
Well, I think the right to life of the unborn should be justiciable. It's just another right. There's nothing sort of special about it. So I think a proper homicide law would include, not as a special charter about abortion, but it would include the unborn. But the rules about the unborn would be analogous to the rules about the born, but not identical. So there would be a sort of subdivision of the homicide law. So that should be justiciable. But and I think thoroughly conceptions of human relationships which are thoroughly opposed to the marital family should be opposed in the sort of either justiciable or non-justiciable or both parts of the Constitution. That's much more difficult. But because considerations of personal liberty come much more directly and as it were plausibly into play than they do when another human being has been conceived and is alive and real. So I think there negatively, it's a tragedy that for communities that have adopted the idea that marriage extends to people of the same sex, people who cannot conceivably have a child between them, that's the child of both of them. To call that marriage is a disaster for a community. It's an untruth. It's an injustice to the children that depend on a stable and vibrant sense of what marriage is and its responsibilities. So, and then similarly, the problem about gender and the identity of man and woman, male and female, female and male, and so forth. So again, it's a tragedy for communities to elevate the self-description of someone as belonging to another gender to the status of the law, of legal right. And the prohibition of teaching children truths about there being boys and girls, men, women, and so forth. And the whole elaborate set of secret arrangements made by non-parents with the children to change their gender, etc. All that's disastrous. Whether it can be kept at bay by constitutional legal devices is something that is unanswerable in general, and each community needs to do its best with what it can agree to.
Let me have an intervention, please, about this question, because in the English-speaking world, social issues many times are understood as these precise issues on abortion and gender and marriage and so on. And so yes, there was a misunderstanding in the question, because we in our part of the world are calling social rights to those economic.
Yes, no, and that's how I hear the term too. But yeah, something about and context of the question steered me off to.
Yeah, and so the question is, because we understand that if the judicial power can stop the state, for example, from killing people or from incarcerating unjustly some person and so on, these sort of very defined rights, but could rights which demand, for example, a dignified place to live, a dignified house, or rights which demand a higher quality of education or health services and so on, be specified by judicial ruling instead of by legislative arrangements and by law? That was the question.
Yeah, well, obviously it's possible, and it's been tried. I don't know what your experience with it has been in Chile. It's been tried in India. It's being tried all the time in India, which adopted a very sophisticated British, American, etc. type of constitution in 1949. And it had these social non-justiciable rights and then justiciable rights, and some overlap and some clarity. But I'm inclined to say that the judiciary there, as well as here, and probably in your part of the world, is not especially competent to make good judgments about these matters. If your legislature is, or if some country's legislature is corrupt and incompetent, then the judiciary may be better. But typically, I'd say they aren't. And it's for each people to, as it were, identify for itself whether its legislature is likely to be corrupt and incompetent. So much so that it needs the help of the judiciary, who on the whole are, as we say, out of their depth in these matters. They're not experienced in, law school doesn't train you to think competently in matters of economy and so on. But if the legislature is systematically ignoring the housing problems of the poor, or some section of the poor, especially if it's some identifiable section that the judiciary can, as it were, contain in some concept, then it may be that that's a good solution.
Okay.
There's no universal recipe, I think.
Yeah, I think it's a matter for determinatio of the natural law in a given community. Okay, Javiera, we should.
Okay, we should round up.
Mm-hmm.
Okay. Do you think we have time for one last question that someone made, or do you think Professor Finnis, do you have 5 more minutes?
I've got hours. I'm not in my lunchtime.
Okay. Okay. Okay.
Just one, because the other people in the room need to go to.
Yes, this is the last one. Okay. Also, regarding our new constitution, there is a discussion regarding the rights of the animals. So do you think that natural law could support an environmental law that protects the environment and also certain species of animals? Do you think that there is something of natural law there that we could use, or that is useful for that matter?
I think animal rights are a threat to human rights, because saying that animals have rights of a kind that's in any way comparable to human rights, I think destroys the intelligibility of human equality. So we say to ourselves, and rightly say to ourselves, that all human beings, whatever their condition, their infancy, their disability, their senility, etc., are equal to each other, whatever their race and gender, etc., etc. But that idea of equality becomes unintelligible if you say, and also baboons or dogs and so forth. So the idea of human dignity is the idea that all humans are of a higher level of being than all subhuman beings, subrational kinds of being. Now, that doesn't mean, of course, that it's reasonable to treat them with contempt. But what counts as unreasonable in this matter needs to be kept in line with that more fundamental truth that human beings are equal and have dignity that all other animals lack. I think on the whole that the community's self-interest of a fairly straightforward kind is sufficient by and large for it to respect the environment enough for its future generations to be living in a wholesome and acceptable environment. it doesn't need to be guaranteed by artificial analogies to human rights.
Okay, thank you very much. I would like to ask all who are in the room to turn on their images so that we can record the last picture with Professor Finnis and all of us as a gallery. And then here I see Patricio, good, and Constanza, Catalina, Pablo, Juan Pablo, Max, Catalina, Carolina, and everybody. And I'm going to move the camera and to say goodbye to Professor Finnis, and everybody can say goodbye until we stop this. Okay, ready?
Thank you very much indeed.
Thank you, Professor.
Thank you, Professor Finnis. Thank you very
Finnis.
much.
And all good wishes for your future studies and career.
Thank you.
Thank you.
Thank you.
Thank you very much. Goodbye, and goodbye to
Goodbye.
everybody, and to the next occasion. Okay, I'm going to stop the transmission. Bye,
Very good.
Professor Finnis. I shall meet you again, I hope, there. Thank you. Thank you very much. Bye. Goodbye.